Good day everyone, we are the third group from BAPS 32 and this report is all about international law and practice. The following subtopics will be discussed in this report. First is the definition in general terms, second is the treaties and treaty making, third is the political asylum and the extradition of criminals, fourth, the recognition of states and governments, fifth is the extent of state sovereignty and jurisdiction, and lastly, nationality. Definition in general terms. So, international law, or also known as law of nations, is defined as a system of treaties and agreements between nations that governs how nations interact with other nations, citizens, and businesses. So, basically, it acts to regulate the ways in which different states interact with one another. It is also an independent system of law existing outside the legal orders of particular states. Jeremy Bentham, an English philosopher, first coined the term international with the word jurisprudence in 1789 to replace the term law of nations. So, Jeremy Bentham also defined international law as a collection of rules governing relations between states. According to J.J. Stark in his book Introduction to International Relations, he defined international law as that body of law which is composed for its greater part of the principles and rules of conduct which states feel themselves bound to observe and therefore do commonly observe in their relations with each other. So just like Jeremy Bentham's definition, so J.D. Stark also mentioned here the rules governing relations between states wherein these states are bound to observe these laws. On the other hand, there are three types of international law. First is the public international law, which is concerned with the treaty obligations between different nations and individuals and deals with those nations and persons that may be affected by those particular laws. So, some of the principles of public international law are written or codified in a series of treaties, but there are also others which are not written or unwritten or so-called customary laws. So these the nations consent to them by doing nothing. And here there are aspects of public international law, namely customary public international law, which involves regular state practices that rely on opinion juries. Opinion juries means it is the belief that an action is carried out because of a legal obligation to do so. So, second aspect of public international law are the globally accepted standards that govern behavior. And lastly, the third aspect is the legal codes that are written into agreements referred to as treaties. So, the next type of international law is the private international law, which involves determining which jurisdictions laws are applied in transnational cases. So, it governs private conflicts between individuals rather than between states. So, the main difference between the public international law and the private international law is the conflicts between individuals. So, in private international law, it governs conflicts between individuals, while in the public international law, it governs conflicts between states. Lastly, the third type of international law is the supranational law, which refers to the situation wherein nations surrender to the court their right to make certain judicial decisions. It encompasses the functioning of bodies with international jurisdiction. Meanwhile, there are four sources of international law according to the Statute of International Court of Justice. So these are the treaties and conventions, customs, general principles of law, and judicial decisions and teachings.
Good day everyone, my name is John McGillian and I am here to report the treaties and treaty makings with my partner Angelo Gilonga. So let's start with types of treaties. The first one is agreement. No? An agreement is stating the compliance and support the aims of treaty. So yung agreement is a harmony of opinion para malaman kung ano yung susunod na act at kung dapat napagkasunduan to ng dalawang parties. kung ano yung action na gagawin nilang susunod. So, the next one is the arrangement. The state of being ordered and an act of arranging. So, yung arrangement is dapat ito yung may nasunod yung order ng inyong gagawin or dapat may systematic way siya at nasunod nyo yung gagawin na yun. So, the third one is convention. So, convention is a meeting of several countries which to form an agreement or a treaty. So, the fourth one is declaration. Declaration is statement made by a party to a legal transaction, usually not under the oath. So, yung declaration is parang yung suggestion or statement ng isang party na ilalagay sa isang treaties na dapat din is mapagkasunduan ng dalawang parties. So, the fifth one is the exchange of notes. So, made by independently of a treaty, less formal means of recording agreement between states. So, yung exchange of notes is less formal siya ng recording ng agreement between states and parang ito yung minsan practical siya na gawin kasi mas mapapabilis yung process of treaty. So the next one is the General Act. So General Act the examples are Bill of Rights or the Constitution itself. The next one is the modus vivendi. So, modus vivendi is a feasible arrangement or practical compromise. So, yung modus vivendi is arrangement siya kung alin yung mas practical na gawin or mas madaling gawin para ma-benefit agad yung treaties or yung napagkasundan ng dalawang countries. So, the next one is the process verbal. So, process verbal is the official written record. So, ito yung official written record na ng bawat parties, na review na ng bawat party. So, the next one is protocol. So, protocol is a preliminary memorandum and the original draft of the treaty. So, the last one is the statute. Statute is the law enactment by the legislative branch. So, part of other parts of treaty is the final act, a series of agreements or treaties resulting from a conference which requires approval. So, ito yung final act. Ito na yung ilalatag nyo na yung treaties nyo, both parties, kailangan na approval ng both parties, tapos magkakaroon ng conference call para mapag-usapan yung revision or kung may babaguhin pa sa treaties na ginagawa nyo. So, protocol signature, a postscript of treaty that is written and signed separately. So, yung protocol signature is parang another document or another copy of a document para lang na may signature ng both parties para sa kanilang references. So, the last one is the protocol. So, protocols written as a supplementary or to amend a treaty.
Hi there, this is Angela Garonga, and I'll be continuing the discussion for the process of the treaty making. So I was advised by JM that I'll be explaining about the process of treaty making. Okay, so for the first part of it would be the accreditation and full powers. To make a treaty, the other person must be able to prove his credentials through a letter signed by or on behalf of the Minister of Foreign Affairs and must be provided with full powers or authority. Okay, so before we process or we even codify the treaty itself, first thing is that we must have a person that is able to prove his credentials or through a letter signed or on behalf of the Minister of Foreign Affairs. So basically, pag gagawa tayo ng isang treaty, before we even try to compose or write the treaty itself, kailangan muna magkaroon tayo ng specific person wherein wherein siya yung parang maglilid nung treaty mismo or nung pagsasagawa ng treaty na yon, and that person must be able to prove his credentials. Okay, so the next one would be the negotiation process. Okay, so for this one, nagpe-proceed through a letter of intent, and for multilateral negotiations. Okay, so dapat merong munang agenda to be set first beforehand. Okay, so multilateral meaning to say na maraming hindi lang to between countries. This is like a convention, and there should be an agenda first para alam ng mga magpapartake dun sa multilateral negotiation na yon kung ano ba yung pag-uusapan or ano ba yung itatakel dun sa treaty na yon. Okay, and the last one, for bilateral negotiation, hindi siya yung mismong agenda. Ang nire-require nito is just an outline or just an outline of the agreement na pwede nating i-subdivide. Okay? So, yun po yung for negotiation. Then, the next one would be the authentication and signature of the text. Okay? So, meron tayong mga iba't ibang klaseng signatures para ma-authenticate natin na valid yung isang treaty. Okay, so the first one is initially. Okay, so initial meaning to say it signified the establishment of the authenticity of the text and still requires additional consent. Okay, initially parang nilagay mo lang yung name niya, pero dapat certify niya yung authenticity ng text, pero dapat meron pa ring additional consent or na magpapakita ng na pinapayagan or approved or authentic yung ano na yun, parang additional evidence ba. Okay, so the next one is signed ad referendum, signifies confirmation by the state concerned to constitute full signature. Okay, the next one is a treaty subjected to ratification. Signature is of limited significance, and the last type of authentication process is the multilateral treaties. May be signed with reservation if it's not excluded in the terms of the treaty or incompatible with the object and purpose. Okay, or sorry, the objective and the purpose. Okay. So for this, the next one would be the ratification. So for this ratification, once the treaty is ratified, it will be referred to the government of the negotiating parties for confirmation. Okay? So kung ang treaty is na-sign na, ibibigay ito dun sa government ng negotiating parties or dun sa government ng dalawang parties na or nung dalawang government na magpapartake dun sa treaty na yun for confirmation. Okay, so the next ratification is an executive act made before the legislative implement the treaty. Okay, so this ratification, ang nagsasign nito, like for example here in the Philippines, presidente ang magsasign nito before i-implement ng legislative or before maging batas sa Pilipinas or sa society. Okay? So, state is not obliged to ratify a treaty agreed by its delegate, but its a choice of action is limited to the complete rejection or acceptance. Okay? So, for this one, yung state na binigyan or na nag-offer or binigyan ng offer about a treaty, hindi naman siya obliged na i-ratify agad yung treaty. Meron siyang karapatan na parang i-decline yun na hindi mo na kailangan na hindi niya na kailangan mag-explain pa or what. Okay? So ratification made with reservation is a procedural nature rather than substantive. Okay? Reopening of negotiations to make amendments is not allowable in the process of ratification. Okay? So, parang ano lang to, parang kang nasa third reading ng isang batas. Okay? So, 'di ba sa paggagawa ng batas sa Pilipinas, we have the first, the second, and the third reading. The first reading would be the title and objectives of the law. The second one would be the amendments and the full reading of the text, or the text of the law, of the bill, sorry. And on the third one would be the finalization, or the for the finalization of the bill. Okay, so parang ganun siya with the ratification. Pag nasa process na siya ng ratification, hindi na pwedeng magpupush ka na naman or mag-open ka na naman ng isang statement na gusto mong ipabago to. Once it's in the ratification process, hindi na muna siya pwedeng baguhin. Okay? Ratification is not retroactive to the date of the signature of the treaty unless a special provision is made to this effect. Okay? So, for ratification, hindi siya retroactive. Okay? So, parang to the date of the signature of the treaty. Okay? So, ratification, ni-ratify siya ngayon, hindi ibig sabihin na yung the past years or past days bago yung araw na yon is kasama na sa treaty na yun. Magsisimula lang yung treaty once ratified on the day na na-ratify siya mismo. Okay? So, for this one, I'll be passing the baton to my partner, John Mark Gillian, for the continuation of the process of policy making.
So continue the discussion of process of treaty making. I am John McGillian, reporting the acceptance. So acceptance is made as an alternative to ratification, accession, and adherence, and is affected by the deposit of the instrument of acceptance. So yung acceptance, naging alternative ratification siya kasi kapag hindi pa na-ratify yung isang treaty, pwede siyang, pag in-accept siya ng both parties, pwede siyang i-deem as valid, or parang pwede nang gawing siyang gawin, yun. So, the next one is the accession and adherence. So, multilateral treaty may include provision for subsequent accession and adherence to state that did not originally sign the treaty. Sa multilateral treaty, yun, yung isang state kahit hindi siya sign sa or nag-originally sign sa isang treaty, so pwedeng may mga provision doon na kailangan pa din sundin ng state na yon. So accession is the whole treaty itself. So next one is adherence. So adherence is the specific provision of a treaty. So, it will only take effect with the consent of all the signatories of the treaty. So, the next one is the exchange or deposit of ratification. So, effective and recorded by means of process verbatim. Again, the process of verbatim is the written agreement of a different party. So, yan, affected siya nun and recorded siya nun. So, next one is instruments of ratification are signed by the head of state, by the head of government, or by ministry of, or for foreign affairs. So the next one is the registration and publication. Upon the completion of the treaty, it must be registered with the secretarial and published by it. If not, it may not be invoked in the International Court of Justice or the United Nations. So, dito sa registration and publication, so, kailangan siya na-approve or na-deem as registered at na-publish ng Secretariat, dahil kapag hindi, parang mavo-void yung ginawang treaty ng, or pag walang agreement or signatory, mabo-void yung ginawang treaty. Parang sa journal, kapag yung isang laws kahit ratified na, at hindi pa rin na-publish or parang publish sa official gazette. So parang hindi siya magiging acceptable or parang hindi siya magiging effective.
Hi, this is Angelo Garonga once again, and I'll be finishing up the discussion about the treaty process or the treaty making process by starting with the form and content of the treaties. Okay, so for this one, the first part of a treaty would be a preamble, and with the preamble, it should contain the names of the parties in the government, the names of the plenipotentiaries, and the object of the agreement. And for this, the second part would be the terms of or substance of the agreement. Okay, so it should contain a substantive clause containing what are the terms of the agreements. Okay, or the agreement or the treaty itself. Okay, the next one is the third part would be the administrative clauses or the final clause. Okay, so for this one, watch for the this part. It should contain the date or method of entry into force of the treaty, the duration and method of the termination of the treaty, definition of terms, the method of settlement of any dispute, reservations, accession to the treaty by other states, amendments of review, and the languages of the treaty which are to be authoritative, and ratification and deposit of instruments or of ratification, registration with the United Nations, date and place of signature, and the signature itself of the plenipotentiaries. Okay, that would be the parts or the content of the treaties. Okay, so let us proceed with the validity of the treaties. Okay, so for this one, treaties may only be ended on the following grounds deemed by the articles 48 to 53 of the Vienna Convention on the law of treaties in particular. Okay, so for this the validity of the treaties, the only way for you to be able to end a treaty itself is by basing the reason to the articles 48 to 53 of the Vienna Convention. Okay, the first is error relating to a fact or situation which was assumed by the state concerned to exist at the time when the treaty was concluded, and which formed an essential basis of its consent to be bound by the treaty. Okay, so if there is an error, assuming that the state says that there is an error with regards to the treaty, that's the only time. That's the first way for you to be able to end the treaty itself. Okay, next is due to fraud, when a state has been induced to conclude a treaty by the fraudulent conduct of another negotiating state. Okay, for this one, like for example, tinatakot yung isang bansa just to sign the treaty. That should be that's one of the ground for you to be able to cancel or eject yourself from this treaty. Okay, next is corruption of the representative of the state, coercion of the representative of the state, coercion of a state by the threat of use of force, breach of jus cogens, treaties conflicting with the peremptory norm of general international. Okay, so what is the peremptory norm? Accepted and recognized by the international community of states as a whole or as a norm. Okay, the last part for the process of treaty making would be the termination of the treaties itself. So okay, so with regards to the treaties, since this is a treaty process or treaty making process, so hindi lang naman laging start Okay, so dapat meron pa ring clause about kung gusto na ba gusto nang i-eject or tanggalin ng isang state yung pagiging signatory niya sa isang treaty. Okay, so the termination of the treaties may come to an end when first expired na yung time limit ng treaty. Okay, next the other one is kung i-use nila yung termination clause as per said in the Article 48 to 53 of the Vienna Convention. Okay? So, for this one, the varying degrees of legitimacy can be claimed for such a unilateral action in the event of A. A fundamental change having taken place in the circumstances which existed at the time the treaty was drawn up. The extinction of the other contracting party as a state in such a way that the successor state does not inherit rights or obligations under this treaty, and the other one would be the outbreak of war. So, if by any chance that that a state is under a war with another signatory of a treaty, or yeah, to another signatory of a treaty, that may end the treaty itself between both countries. Okay. Next is the denunciation of a multilateral treaty by such a number of the parties as to render the treaty inoperative. And the last one for us to verify, or to verify the validity of the reason, is a material breach of the treaty by another party to it. So if there is a breach by the other party dun sa mismong treaty, maaaring i-cancel yung treaty na yon. Okay? So for that one, we've just finished explaining about how a treaty is processed and how a treaty is made. So for this one, we will be continuing the discussion with our colleagues here. So once again, this is Angelo Garonga from BAPS 32 and my partner here.
John Mark Gillian.
Okay, so we've just completed our task with regards to this with regards to the types of the treaties and process of the treaty making process. So thank you so much for listening. Please do listen to our colleagues here. Bye for now.
Good day, I am Erica Rose H. Lochica. I am going to discuss about the political asylum together with my partner Francisca Mil Mojica to discuss about the extradition of criminals. For political asylum, asylum is defined as the protection granted by a state to a foreign citizen against his own state. The person for whom asylum is established has no legal right to demand it, and sheltering state has no obligation to grant it. It means that ang asylum daw, ito yung mga tao na nagaling sa kanilang bansa tapos nagpunta sila sa ibang bansa, tapos yung taong yun mabibigay siya ng protection nung state na pinuntahan niya laban dun sa pinanggalingan niyang bansa. There are two categories of political asylum. It namely territorial asylum and diplomatic asylum. Territorial asylum is granted by a state to an alien its territory. And the next one, diplomatic asylum, is the premises of diplomatic mission or other such premises entitled to be in a violation. A state has the right and duty in cases covered by the Refugee Convention to grant asylum to alien within its own territory. For the territorial asylum, it was granted by the state to its territory. Sa diplomatic asylum naman, it was the premises of a diplomatic mission para makover siya ng Refugee Convention para mag-grant yung mga asylum sa territory na to. There are 11 Latin American practices summarized by the Convention on Diplomatic Asylum from the 10th Inter-American Conference in Caracas held in 1954. First, it was stated that every state has the right to grant asylum and to determine itself the nature of offense or motives in the prosecution of the person seeking asylum. Yun nga, sinasabi dito na sa bawat estado daw, mayroon silang karapatan para mag-grant ng asylum. Tapos, i-determine nila kung ano yung nature ng offense, tapos yung motivation para sa bago sa persecution ng mga taong naghahanap ng asylum. For the second practice in Latin America, allegation includes not only the seat of regular diplomatic mission and the residence of the head of the mission, but also any other premises provided by the mission for the asylees when their number exceeds to the normal capacity of the building. It means na kapag nag-exceed na sa normal capacity ng building yung tinutuluyan ng mga asylee, pwede silang ilipat o hanap ng bagong lugar basta approve pa rin yun ng diplomatic mission or yung mga namamahala doon. Asylum may not be granted except in urgent cases and for the period of time strictly necessary for the asylee to depart from the country with guarantees granted by the government of the territorial states. Ito yung sinasabi na kapag urgent cases daw at kailangan talaga ng asylee na ma-depart sa country niya, kailangan to pero dapat guarantee na ng government of the territorial state yung kanilang protection. Number 4, ito yung mga urgent cases to be understood. Ito yung halimbawa is the individual thought by a person or moves over whom from the authorities have lost control, authorities themselves, and the danger of being deprived of life, liberty because of political persecution and cannot, without risk, ensure his safety in other way. We shall rest with the start granting asylum to determine the degree of the urgency of the case. Ito yung sa urgent cases, ito yung mga dapat nakapaloob doon. For the number 5, it is not lawful to grant asylum to person who at the time requested it are under indiction or on trial for common offenses or have been convicted by complement regular courts or have not served the respective sentence nor to deserted from land, sea, air forces, save the giving the acts rise to the request for the asylum are clearly of a political nature. Yan. Ito naman yung mga hindi ginagrant ng asylum, yung mga taong at the same time na nagre-request na kung under sila ng indictment or trials. So for the number 6 naman, immediate asylum is granted. The fact must be reported to the Minister of Foreign Affairs of the state of the person who was secured asylum or to the local administrative authorities if the act occurred outside the capital. Ito naman yung mga immediately granted na as asylum kapag ito yung when they were reported to the Ministry of Foreign Affairs of the state of the person who's secured asylum. For the number 7, the government of the state has the right to require that the asylee be sent out of the national territory within the shortest possible time, and the diplomatic agent of the country which has guaranteed asylum in turn has the right to require that the asylees be permitted to leave the territory, and in both instances, the necessary guarantee of safe conduct and inability must be provided. Number 8, asylees enjoy safe conduct may not be deposited at any point in or near national territory which they have sought asylum. While enjoying asylum, refugees shall not be allowed to perform acts contrary to the public peace. Hindi dapat sila gumawa ng ikakagulo ng public peace. As a consequence of a rupture of diplomatic relations, the diplomatic representative who granted asylum has to leave the territorial estate. He must be allowed to live with the asylees, or if this is not possible, he may surrender them to the diplomatic mission of a third state. Lastly, the fact that the government of the territorial state is not recognized by the state granting asylum does not prejudice the application of the general principle set out above, nor does their application imply recognition.
Extradition is defined as the forcible removal of a person from one state to another to stand trial or suffer imprisonment for an alleged offense, and requests for extradition arise when a person who is accused or convicted of a criminal offense seeks refuge in another state. Applications for extradition are made through diplomatic channels and are reasonably straightforward, where both states have agreed to specific principles in advance through the medium of an extradition treaty. So, an extradition is a formal process wherein one state is surrendering an individual to another state for punishment for the crimes committed in the requesting state's jurisdiction. So, as I've mentioned earlier, it is enabled by a treaty. It could be a bilateral or multilateral treaty. Principles of extradition. The person whose extradition is sought must be a national of the state seeking his extradition or a national of a third state. It is not normally the practice for a state to hand over one of its own nationals at the request of another state, though the United Kingdom and the United States of America are exceptions to these general rules. The second is the alleged offense for which extradition is sought must be a grave one. It must normally be an offense in both states involved, and adequate details of the individual's implication must be provided. Offenses for which extradition is not normally applicable include political offenses, military offenses such as desertion, and religious offenses. So basically, the state who should be requesting for extradition is the other state or a third state, or um, the main state wherein a person is the national itself. However, in United Kingdom and United States, they could hand over their own nationals at the request of other state, and it was also stated in here that the offense for which extradition is sought must be a grave one or a heinous crime, except for the political offenses or military offenses and religious offenses. On the other hand, the European Convention on Extradition contains specific circumstances wherein extradition is not applicable. First, if the offense in respect of which it is requested is regarded by the requested party as a political offense or as an offense connected with the political offense. And the last one is if the party has substantial grounds for believing that the extradition for a criminal offense is for prosecuting or punishing a person based on his race, religion, nationality, or political opinion.
So, recognition of states and government. So, first, recognition of state. Under international legal system, the formal acknowledgement or acceptance of a new state as an international personality by the existing states of the international community. It is the acknowledgement by the existing state that a political entity has the characteristics of a statehood. It may be noted that recognition is neither a contractual arrangement nor a political concession. It is the declaration of the existence of a certain facts. So, under international law, Article 1 of the Montevideo Conference 1993, it defines that a state is like a person and lays down the following essentials, and it said that in order to be recognized as a state, it should acquire the following. It was like the elements of the state. First, it should have a permanent population. Of course, it is very essential that a state should have a population, people. And number two, it should have a definite territory, should be controlled by it. And of course, a state should have a exact measures of its territory. because it is very important, because it is part of the state, and it is where the population or the people living. Okay, number three, government. Of course, it is very essential that a state should have a government because they serve the population, its constituents. And last, the entity should have the capacity to enter into a relations with other states, of course. And there are two modes of recognition of a state. It is a de facto and de jure, or de jure. Okay, so in de facto, it is a provisional recognition of statehood, and it is a temporary and factual recognition as a state, and it can be conditional or not. It is not a process of law, but it is based on a factual situation, and it is temporary and it can be withdrawn. There are some de facto states, and these are the examples of Abkhazia, Somaliland, and Turkish Republic of North Cyprus. Most of the de facto states cause civil wars, and when a de facto state arises within the territory recognized as a governed by some official state, they tend to protect the independence of the de facto states or to reassert the sovereignty of the official state over its territory. And the second one, the de jure recognition of a state. It is a recognition of a new state by the existing state when they consider that the new state fulfills all the essential characteristics of a state, which I mentioned earlier: the population, the territory, the government, and the entity, that they are capable to enter in a relations with other states. It can be granted either with or without granting de facto recognition. And it is granted when the newly formed state acquires a permanent stability and statehood. Of course, it is very important that a state should stand by itself, that it can provide. Also, it grants the permanent status of a newborn state as a sovereign state. De jure recognition relates to a process that is contemplated by law. De facto, that it is based on a factual situation only. And that's all for recognition of state.
Greetings, Ma'am Giselle. I'm Danica Rose Malan, and I'm going to be discussing about the recognition of the governments in the international law. So, by the recognition of the states and the government in international law, the state has four elements, and these are territory, people, government, and the sovereignty. So, first, let's define what government is. So, the government is the institution inside the state that is composed of the body or entity that provides the policies that governs that entity inside the state. So, the following functions of the government is that the government serves as the agent of the state. The government is the body that provides the rules and the policies for the people. And the government also embodies the will of the people. And lastly, the government represents the state in the diplomatic intercourse. So when it comes to the recognition of the government in the international law, a new government should provide following requirements, like it must be effectively controlled by a larger or greater part of the state territory. Second is that it must be followed by the people living on it. And lastly, it should have a reasonable prospect of permanency in order to be recognized. And there are two modes of the recognition of the governments in international law. The first one is the de facto recognition. So when we say de facto, it is like it is not officially recognized by the laws, which means that the government in the sovereign state is allowed to exercise the normal international functions with reciprocal responsibilities in international law. Pero they are not usually not able to conclude and formally sign bilateral treaties and establish formal diplomatic relations. While in de jure recognition of governments, by the word de jure, in contrast with de facto, it is officially recognized by the laws. So in de jure, it is the legal recognition, meaning the government recognized formally fulfills the requirement that was laid down by the international law. And since de jure is the legal recognition, the normal and complete relations can be maintained.
The extent of state sovereignty and jurisdiction. Sovereignty. The territorial sovereignty of a state extends over the land within the state border. So, ang territorial sovereignty ng isang coastal state ay nag-e-extend sa mga katabi nitong island. So, sa mga island na yon, meron pa rin sovereignty ang isang coastal state. And the airspace above it. The territorial water of a coastal state is 12 nautical miles from the territorial land, while the contiguous zone measures 24 nautical miles from the territorial water. So, from the territorial land, we will measure 12 nautical miles, and yung area na yon, yung 12 nautical miles na yon ay considered as territorial water. And from the territorial water, yung next 24 nautical miles na area na yon ay ang contiguous zone. And the exclusive economic zone measures 200 nautical miles from the contiguous zone. So, from contiguous zone, the next 200 nautical miles will be the exclusive economic zone. So, the coastal state can share the EEC's economic resources. The state have no sovereignty in this area but have sovereign rights. So, ang isang coastal state ay wala ng sovereignty dito sa area na to, sa EEC, kundi sovereign rights na lang. The foreign vessels can freely navigate to the territorial water under the condition that they are just passing by and not violating any rules. So, yung mga foreign vessels, they can freely navigate around the territorial water. Kaso may mga conditions. The international regime for determining maritime legality is based mainly on the 1958 Geneva Convention and the 1982 Law of the Sea Convention. The major provisions of the conventions include coastal state exercise sovereignty over their territorial sea up to 12 nautical miles in extent, but foreign vessels are allowed innocent passage through those waters for purposes of peaceful navigation, and permission to overfly is subject to the approval of the coastal state. So, yung kaunahan ng na-mention, ayun nga yun, yung nilalaman ng mga conventions na ito, which is ang coastal state ay may sovereignty sa territorial sea or territorial water na nagme-measure or may measurement na 12 nautical miles. And yung mga foreign vessels ay allowed na mag-navigate doon sa area na yon. And the second provision is coastal state have sovereign rights in a 200 nautical miles exclusive economic zone with respect to natural resources and most economic activities, and are also entitled to have a certain degree of jurisdiction over scientific research and environmental protection. So, na-mention din to kanina, itong provision na ito. Yung sa EEC na na may measurement na 200 nautical miles. So, pwede rin mag-navigate yung mga researcher dito sa area na to. But, yun nga, bawal mag-violate ng rules.
So, nationality. An international law dictates that all states are to acknowledge individuals' nationality that are given to them by their states. Only their state can determine on whether these individuals have complied to the requirements they needed in order for them to be recognized by the state as a national. A subsequent principle under the fundamental principles being laid out in the Hague Convention of 1930 stated that if a person has a weak association with a state, then its nationality cannot be granted and cannot be acknowledged by the state as its national. So, yung state lang yung may kapangyarihan na i-grant ang isang individual ng kanilang nationality or ng kanilang pagkakakilanlan. So, since state lang ang may kapangyarihan na magbigay ng nationality, yun nga, sila lang rin ang may kapangyarihan na tanggalin ang pagkakakilanlan ng isang tao sa kanyang bansa. Sa pagkuha kasi ng nationality, meron tayong tinatawag na ius soli at saka ius sanguinis na explain mamaya ni Christian Maglasang. So, nationality rin yung legal identification ng isang tao sa kanyang bansa. May mga estado kasi na kapag kunyari ang isang tao ay kinoconsider nilang tawag doon, parang ine-exile nila sa kanilang bansa. So, parang tinatanggalan siya ng nationality. Sabi sa Article 15 ng Universal Declaration of Human Rights, sabi na everyone has the right to a nationality and no one shall be arbitrarily deprived of his nationality nor denied the right to change his nationality. So, lahat ng tao is may karapatan na mabigyan ng pagkakakilanlan or ng nationality at hindi sila pwedeng pagkaitan nito.
Nationality. Ano ba ang nationality? Ito ay tumutukoy sa lahi o pagkatao ng isang mamamayan o lugar ng kanyang kapanganak. Kunyari, ako pinanganak ako sa Pilipinas. Bali, Pilipino ang aking magiging nationality. Ang isang mamamayan na may nationalidad ay dapat magpakita ng kanyang pagiging nasyonalismo. Kasi sa nasyonalismo is nagpapakita ito ng pagmamahal sa ating bansa o pagiging makabayan. Paano nga ba natin ito mapapakita? Para sa akin is mapapakita ito kung ang pagiging nasyonalismo sa pagtangkilik sa ating produkto at higit sa lahat ay pagmamalaki sa ating sariling wika. Dumako naman tayo sa two methods of acquiring nationality. Una dito is jus soli. Ito ay isang pagkamamamayan ng isang tao base kung saan siya pinanganak. Yung jus sanguinis naman ay kung saan yung jus soli is nakabase, di ba yung jus soli is nakabase sa kung saan siya pinanganak. Dito sa jus sanguinis is parang namamanas sa pagkamamayan ng kanyang magulang. Dumako naman tayo sa dual citizenship. Ano nga ba ito? Ang dual citizenship ay isang pagiging mamamayan ng dalawang bansa. Ang advantage nito is parang madali na lang sa'yo na mag-travel kung saan-saan. Tas yung pagiging disadvantage naman nito is para sa akin yung pagiging disadvantage nito is parang dalawa yung tax na babayaran mo. Ayun lang po.